Madam Chair, Mr. Vice Chair, members of the committee, John Willems representing the Maryland Association of Boards of Education, here today to testify in opposition to House Bill 1240 and the shifting of the burden of proof to school systems and away from the moving party. This committee is quite familiar with this issue, having heard this bill in years past, and so I won't revisit my written testimony, which is lengthy. I would stress that the Supreme Court has decided the Andrew case, and the standard that it did address was the de minimis standard. The Fourth Circuit does have a lower standard than some other circuits, and so the Andrew case will have some impact on the Fourth Federal Circuit in which Maryland is located, because they do refer to some benefit as the standard as opposed to the meaningful or ambitious goals standard that the Supreme Court established. So that is an important and I think positive development. With regard to this legislation, one of the issues this committee has wrestled with that is raised by this bill again this year, as amended in the House, is the question of petitions for placements in non-public schools, those unilateral placements. And the bill did explicitly exclude those types of decisions as introduced, but that was amended out of the bill by the House, by the Ways and Means Committee in the House of Delegates. So we would urge this committee to look at that provision that no longer clearly excludes those cases in which a parent or guardian is seeking the tuition reimbursement for those very costly non-public placements. Secondly, the bill has been amended to include a new provision which we believe could shift the burden of proof in those cases arising from proposed changes to the services provided at every annual meeting. And so if you don't specifically address the non-public placements and you allow every year the burden of proof to be shifted with regard to basically anything that comes up at that annual meeting, you've opened the door for those types of decisions to be considered in a way that basically has for several years been rejected as an element of the bill to shift the burden of proof. Lastly, representing local boards of education and the professional educators and administrators who serve in the 24 school systems, this committee has heard me say before, the vast majority of our special educators are doing a wonderful and dedicated job. The special education law is still relatively new in that most of us, probably Senator Zucker excluded, when we were born, there was significantly less federal law and protections relative to special education anywhere in the country for anyone. So it's a generation old, like a lot of our civil rights statutes. And this is really a civil rights issue for students with intellectual and developmental disabilities. And so it is a work in progress. There is always room for improvement. We do provide parents with ample information now in advance and immediately following the IEP meeting. We have done some incremental things legislatively to improve the process that I think we can be proud of, but we don't believe shifting the burden of proof to the school systems and essentially devaluing and presuming to be questionable, if you will, the work of our professional educators is the appropriate way to go, and we request an unfavorable report on the bill. Thank you.
Quick question. Did I understand you correctly? Did you say, and I understand what you're saying about statues, but I might have been a little distracted because I thought you said that the civil rights statues were decades old. Did you say that?
We're decades old?
Yeah.
Well, 1965, Civil Rights Act, Voting Rights Act, and that was around the same time that the education world was starting to address special education. It wasn't until the early 70s that the first special education law actually took effect and governed all 50 states in the manner that's evolved from that point forward. But so, yes, I was born in 1964, so.
So was the implication, but those civil rights statues and the disability statues, they were placed there for a reason, and I'm saying we in 17, 18, I get confused when you're down here. But let me tell you something, they were put there for a reason. Do they need to be updated? Yes. But they had a specific reason to be placed in statute. And the purpose of that rationale for putting this there was because of the unequal treatment of certain groups. And the disabled, women, African Americans, Native Indians, and you don't want me to go on. So I don't know what you were implying. Do we need to update them? But when something doesn't work, it probably needs to be updated. But you implied that they were just old and it was decades ago and maybe we should be doing something else. And I feel that we should never be doing something else if in fact it is not the benefit to those groups that are being discriminated against or receiving unequal or unequitable educational interventions.
Madam
Was
Chair,
that
if I-
what you were implying?
Well, I think clearly, you know, I'm not all that good at this. I was stating the opposite, which is that this is a relatively new endeavor. It's within our lifetime that we have taken this issue in particular so seriously that we've adopted federal law to address the special education needs of students. And so it's only in our lifetime that there's been a panel of 8 people convened to look at an individual student's educational needs in something that we've come to know as an IEP team. That didn't exist, you know, 50, 60 years ago. It is a relatively new thing, and it's very important, and we understand that parents want schools to do absolutely everything we can on behalf of their child, but the standard is something that's intended to provide improvement, educational improvement for each individual student through the plan.
Okay, you just redeemed yourself. Thank you.
Okay.
All right, as long as we're heading in that direction.
Thank you very much, Mr. Vice Chairman. I was just going to say that even though I look young, I hope my kids don't have to wait until they're 42 to finally resolve one of these issues. So, isn't that so? Thank you. Yes.
Thank you, Vice Chair. My biggest concern is the kids. But at the same time, it's the parents. You see the example that we had here, and this is one of probably of many that we have a very serious problem of communication. There's a gap there that needs to be filled in, and I think one of our problems is that we know we have a plan. It's been in place for a long period. We know we have a team, and we know if we use this team properly, I believe things would go well. As I stated, you have areas or places that have been doing this for a long period of time, and they've been doing a great job. As I stated, Kennedy and Krieger, they're above. I think they're beyond the curve. I think there's other places that are learning this, and they're a part of it, and I think they're missing the beat. And I think the problem is we have to make sure that the process doesn't have flaws, and they do, and making sure that communication with the child and the parent and the team as a whole work together. And, you know, I hear what you're saying, but I really so much more hear what they're saying. And I think you got to understand that, and I appreciate that. So, thank you, Mr. Senator. Thank you.
I think, Mr. Chair, Madam Chair and Vice Chair, I think Senator Stallings just kind of articulate exactly what I was thinking, because I've been there with my grandson. And the thing what these parents want you is just to meet them halfway. Just communicate with them to let them know that they're part of this whole team. The team makes a decision. They don't want to feel left out and feel that they're talked down to. They want you to include them. And if they're properly included in the decision-making process, then the problem will go away. Simple as that. So I hope that you convey that.
Absolutely, I will.
Technology is wonderful. I have a friend that's texting me while you're talking. One of the things she said was that the Supreme Court passing in favor of parents is the reason this bill's here. But also, I think you made the statement about costly non-public placements. Has that been proven? How costly is it? How often is it done, and how costly is it?
Yeah, it's absolutely proven in terms of the state budget. So our cost share for a non-public placement is 3 times the base per pupil amount. And so, you know, if that's $12,000, that's $36,000 that the school system pays. And then the state pays 80%, 75% of the excess cost. And so if it's $150,000 a year, the state's picking up the difference. And so they're very costly. We have a network of non-public special education schools. They do comply, I do like to emphasize, with the other rules and regulations that apply to public schools.
Where are they being placed? It costs $150,000 a year.
There are, more than a dozen non-public special education schools in Maryland, and some students are placed out of state, Pennsylvania, New Jersey, and so it's very individualized, Senator. I'd be happy to follow up with specific examples, but
What you're
that's
saying-
not the highest number by any stretch.
What are you saying, 150,000 is the average?
No, it's higher, some places, it depends on where they're being placed. If it's non-public, whether it's in-state, whether it's out-of-state, the intervention techniques, it depends.
No, but I thought I heard him say 150,000.
Yeah, he said average. Yeah.
That's what I asked, is that the average?
I don't know, but that's certainly not an uncommon amount.
So it does range, but I don't think you'll find too many that start below 25,000, which would be twice to 2.5 times what the average public is around the state.
All right, I think that concludes the hearing. All right, thank you.
Thank you.
All right, let me do this real quick. I know a few of you have been here. I'm gonna take the one line